I'm still with niggas got me in that mood. How they hating when they know that I'm that dude? I hear they hating cause they know I got the juice. They like, oh, they watching how I move. Motherfuckers, they be acting like they cool. If you thought this was, nigga, I ain't no fool. Gas in my drink, what you smoking don't flatter me. My niggas got my back, ain't no need for a battery. Blowing all these ones, look like we hit the lottery. My OG just hit me up, he told me that he proud of me. Always going hard, a lot of people that count on me. Always in the studio with next increase in my salary. I remember I was young when they hated and doubted me. Now I need a bar stuff, put my name on the boundary. And now we don't care what it costs. I started to hear the exhaust. Smoking Gucci with my dogs. The way she made it cut, you got it looking like a gloss. I'm getting all these spots and got enough place on my wall. Diamonds dripping like a faucet. Big bag, I want a big bag. If it ain't getting money, you can skip that. Big bag, I want a big bag. Put you in a two-seater, let you kick back. I'm still with niggas got me in that mode. How they hating when they know that I'm that dude? I hear they hating cause they know I got the juice. They like, oh, they watching how I move. Motherfuckers, they be acting like they cool. If you thought this was, nigga, I ain't no fool. Still keep it real, still park the whip and chill, still never popping pills, still got a minute bills, still give them chills, still $100 bills at a crib in the hills, one trip, couple mil. High nigga fall asleep and still making sales, one hand on the wheel, couple bands on the mill, playing on the field, weighing on the scale. In the air for 20 years, I was unavailable. Seen how much of work, started thinking I was dateable. All my niggas getting rich, dudes I done paid a few. Smoking weed by the zip, millions I done made a few. Stacking up and stay another way. Big bag, I want a big bag. If it ain't getting money, you can skip that. Big bag, I want a big bag. Put you in a Rolls Royce, let you kick back. I'm still with niggas got me in that mood. How they hating when they know that I'm that dude? I hear they hating cause they know I got the juice. They like, oh, they watching how I move. Motherfuckers, they be acting like they cool. If you thought this was, nigga, I ain't no fool. I'm still Wiz.
Yes, 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 yes. Since y'all can hear that, let's get this chat call on the way. Queen, you was first. Woo! Yeah, Queen. Hey, stilettos for me. Regina White was good with it. Hey, nobody's fool. Miss Tanya Jones, Miss Tanya Jones was good with it. Hey, Marietta Jones, liar, liar. Hey. Oh, wow, y'all. Well, as per usual, we on time, we on the spot, we on the time. So I just looked and this thing just came out. This goddamn, like I said, we was expecting emotional limine, right? And we have one in from the let me see who this is from. Hold on. From the government. We have it in from the government. So we got that going on, and let me see. Let me look at these dates real quick. Hold on for a minute. I'm not on the screen. I just want to look at these dates real quick. Y'all know Chicago give me a fit with this paperwork, honey. They don't do right. So I told you with the motion and limine, we're going to see what they're asking to include or preclude, right? That's what we're going to do. That's what the function of motion and limine does. We're going to see. Told you about that earlier and yesterday. What's the dates on this? Okay. Hold on, give me a minute. Y'all, I'm trying to get my nose unclogged. Hold on. Yeah, I'm on mute. I'm trying to get my nose straight. Sorry, I'm trying to blow my nose. Hold on. All right. Okay. So, hey, Alvera. Hey, Sonia. Hey, Machina 2. Cool BJ. Okay. So. Let me see. Let me check them buttons real quick. This is a lot to read, honey. Oh, no. Y'all gonna have to like me up more than that. Are you crazy? Uh-uh. Uh-uh. Baby, come on. Hit that like button. This crazy. Hit the damn like button. Hey, Indy's finest. Yeah, like me up, like me up. Keep it moving. So, make it big on the screen. I don't have time to be playing over like button game shit. I'm impatient. All right. All right. So this is the United States of America versus R. Kelly, Darren McDavid, and Milton Brown. This is out of Illinois. It says government's consolidated motions in limine. The United States of America, through its attorney, John R. Loch Jr., United States Attorney for the Northern District of Illinois, respectfully moves the court in limine for entry of the orders admitting or excluding certain evidence and argument at trial in this case as set forth below. Motion to protect the identities of certain victim witnesses. So here we go already. Now they're pushing to protect the IDs of certain people. It says the government moves to protect the identities of the victims named in the superseding indictment, referred to as minor 1, 3, 4, 5, and minor 6. The victim witnesses, who are expected to provide and or will be the subject of sensitive and personal testimony concerning illegal sexual abuse and the production and the receipt of child pornography by the defendants. Specifically, the government moves the court to 1, permit the victim witnesses to testify using their first names only, 2, limit references to each of the victim witnesses in open court to their first names only, and 3, prevent public disclosure via cross-examination or otherwise of the victim witnesses' respective addresses, full names of family members, or exact places of employment, if any. Let me read these footnotes. For the purposes of efficiency and ease of reference, the government has filed its motion in limine in a single document. No single motion herein exceeds the 15-page limit as imposed by the local rules. Number 2, the government also intends to raise at the pretrial conference additional courtroom procedures and logistics to accommodate the victim witnesses, such as the use of separate entrances. See, okay, hold on. Chicago is wearing me the fuck out. They want to handle everything like in one setting, one go. Oh my goodness, this is crazy. Okay. The superseding indictment charges defendant Kelly with multiple counts of sexual enticement and exploitation of the victim witnesses. The victim witnesses are expected to testify in explicit detail and or be the subject of highly sensitive and personal testimony concerning Kelly's illegal sexual contact with them that occurred when they were between the ages of 13 to 17. Due to the sensitive nature of the testimony and evidence relevant to the crimes charged, the government seeks entry of proposed protective order limiting the disclosure of the victim witnesses' last names and other identifying information in court. The limited protections requested by the government are necessary and appropriate to protect the victim witnesses' safety and well being, avoid harassment of the victim witnesses by the press and others, and prevent undue embarrassment and other adverse consequences, such as retaliations by Kelly supporters, relocation, or loss of employment. Oh my gosh. Y'all niggas done struck again. I don't know what to do. What we gonna do? Y'all got me lumped in here with y'all. I promise you, if I go to jail with y'all niggas, I'm gonna beat the shit out one of y'all on the damn wagon here, riding across the get goddamn checked in. God damn it. In addition, the government anticipates that minor one's mother will testify about similar topics related to minor one, including Kelly's long-term abuse of minor one while she was a child. Oh my gosh. Not only did minor one testifying, the mama testified, and the daddy, dead declaration, is going to be in that trial. Unless J-Bo seeks to have that excluded, right? She can do that. She could say she can argue something under the rights to confront the accuser. She could do that. I don't know how successful it will be, because under Crawford, because that's what they're under now. Under Crawford, if they have something to corroborate that or some other type of evidence, then they will probably most likely allow his declaration. So we'll see. As a result, the government similarly moves to permit minors one mother who has the same last name as minor one to testify using her first name only. The proposed protective order also contains a provision related to individual D, who would testify about, among other topics, sexual contact that she had with Kelly and minor one over the course of several years. The government seeks to preclude disclosure of individual D's address, names of family members, and place of employment at trial and during pretrial and post-trial proceedings in this case. The case was charged in July 2019, and since that time, the case has garnered significant attention from local and national media sources. The same is true for Kelly's federal prosecution in the Eastern District of New York. Case law, okay. Oh, it's already, well, no, that's a reference. It's a reference because it's not case law yet, because we don't know how her ruling is. Remember, case law is based on rulings rather than statutory law, which is, so every case does not create a case law. All right. In the Eastern District of New York case, the court granted the government's motion to exclude references to victims' last names and other personal identifying information during the trial. Reference. In sum, a balancing of the risk to the victim witnesses against the defendant's interests supported permitting the requested limitations. The victim witnesses testified about humiliating and explicit acts of abuse, some of which took place when they were minors. The same protocols are warranted in this case. Wow. So they are referencing the protocols that New York took with the testifying under pseudonyms or first names only, the protections they had with regards to their identities, like the address and things of that nature. They're asking that Illinois pretty much follow the same procedure as New York for the same reason, like harassment and all that shit. All the shit we do down here on the block to these motherfucking people, no matter what side you're on. I don't do nothing because I'm in the middle. I'm innocent. Anyway, Several district courts have excluded mention of victims' full names at trial, citing the privacy interests of the victims. Case law. Seventh Circuit 2014, referencing victims who testified at trial under their real first names. Case law. In sex trafficking case, protective order entered precluding reference to adult victims' last names and requiring all documents disclosing the last name of any victim to be filed under seal. Case law and reference. Okay, this was the Western District of New York, 2016. Given the anticipated explicit and sensitive nature of the evidence in this case, the government has a compelling interest in limiting identification of the victims. Reference. It says October 24, 2007, excluding mention of adult and minor victims' full last names at trial, as the government has a legitimate and substantial interest in protecting these witnesses from the likely adverse personal, professional, and psychological consequences of publicly linking their identities to their past lives as sex workers. Huh? Wait a minute. Excluding the mention of adult and minor victims for lessons at trial, as the government has a legitimate substantial interest in protecting these witnesses from their likely adverse personal, professional, and psychological consequences of publicly linking their identities to their past lives as sex workers. Okay, unless they're talking about, was there some charges? Hold on now. Okay, they're not calling these people sex workers. All right, this is what happened in that case with United States versus Paris. Honey, I spent, should y'all see y'all know my head back and turning like the motherfucking exorcist. Like, what the fuck? What the hell is going on? So don't call the people streetwalkers. No, that's not what's going on. Okay, that's not what's going on. They referencing what happened in this particular case. Lord have mercy. As the Gardner court held, excluding evidence of the victims' full names is consistent with the Crime Victims' Right Act. That's the act I was trying to think about. That act right there prevents the defense from asking about like the victim witnesses' sexual history and some other stuff, right? Remember I kept trying to remember the name of the act. I think Levi was up on the panel that day, and I kept trying to remember the name of that act. So yeah. So if y'all want to know why they can't ask certain questions and things of that nature about somebody's sexual history when it deals with a case dealing with sex crimes, that's the name of the Crime Victims' Right Act. That's the name of it. All right. So it says, which states that a victim has the right to be treated with fairness and with respect for the victim's dignity and privacy. Reference. Additionally, the government has an interest in encouraging crime victims, particularly victims of sex crimes, to testify by protecting them from some of the adverse consequences of their testimony. Reference. While the public has a constitutional right of access to criminal trials, that right is not absolute. Reference. A court can inhibit the disclosure of sensitive information when it is narrowly tailored to serve a compelling governmental interest. Reference. In this case, the exclusion of the victim's last name, while otherwise allowing their testimony in open court, is narrowly tailored to serve the interest in protecting the victim's privacy rights. Reference. The court cannot envision a protective order barring mention of victims' full last names that is more narrowly tailored to serve the government's compelling interests. Reference. Excluding mention of an adult victim's full last name at trial, explaining that use of victim's full name would add nothing substantive, to her in-court testimony that cannot be supplied by use of her first name and first initial of her last name. Let me get this, grab this drink. Oh, Jesus. For the reasons set forth above, the government respectfully requests that the court grant the government's motion and one, permit the victim witnesses and minor one's mother to testify using their first names only. Number two, limit references to each of the victim witnesses as minor one's mother in open court to their first names only. And number three, prevent public disclosure of addresses, full names of family members, or exact place of employment, if any, for the victim witnesses, minor one's mother, and individual D. The government further requests that the court enter the attached protective order that sets forth the government's requested relief. The proposed protective order supplements the existing protective order in the case. Reference. Which contains several provisions regarding the disclosure of discovery materials produced in this case, including a prohibition on including any information marked as sensitive in any public filing with the court. Number two, motion to preclude evidence of victims' sexual history. For the reasons set forth below, defendants should be precluded from eliciting on cross-examination or otherwise introducing evidence or making arguments as to the sexual behavior of the victim witnesses with the individuals that Kelly, other than Kelly, or others at Kelly's direction. A. The evidence is inadmissible under Rule 412. By its plain terms, Rule 412 bars evidence of a victim's sexual history and sexual predisposition in cases involving allegations of sexual misconduct, which is what I just told y'all. The following evidence is not admissible in a civil or criminal proceeding involving alleged sexual misconduct. Number one, evidence offered to prove that any alleged victim engaged in other sexual behavior, or number two, evidence offered to prove a victim's sexual predisposition. Federal Rules of Evidence 412A. The purpose of the rule is to safeguard the alleged victims against the invasions of privacy, potential embarrassment, and sexual stereotyping that is associated with public disclosure of intimate sexual details, and to encourage victims of sexual misconduct to institute and to participate in legal proceedings against alleged offenders. Federal Rules of Evidence 412, Advisory Committee Notes, United States versus Cephas case law. This purpose is consistent with other provisions of federal law, which provide that all crime victims have the right to be treated with fairness and with respect for the victim's dignity and privacy. 18 U.S.C. Section 3771A8. Consequently, Rule 412 is interpreted broadly and applies to all sexual behavior of the victim before trial. Case law. The Ninth Circuit in 1991 held that whether offered as substantive evidence or for impeachment. Federal Rules Evidence 412, Advisory Committee Notes. Rule 412 imposes clear limits on a defendant's ability to introduce evidence that a victim engaged in other sexual behavior or has a propensity to engage in sexual acts. In the context of criminal cases, the rule prescribes very limited exceptions to this inadmissibility. And remember, I told y'all, like when it comes to the laws, you got rules, you have exceptions, you have stipulation, you have all types of things, right? So there is more when it comes to the rules of evidence. There is more than rule 401, 42, 43. It's 412. It's some in the 800s. It's a lot, right? This pretty much takes you through this is going to speak with regards to the inadmissibility of it. So it says that the court may admit the following evidence in a criminal case: A, evidence of specific instances of a victim's sexual behavior if offered to prove that someone other than the defendant was the source of semen, injury, or other physical evidence. Meaning that if they have evidence that says that it was someone else's semen other than R. Kelly's, then they can submit that evidence. And that evidence can come by way of testimony or what have you, right? Other than that, they're not going to allow it due to all of that I just read. B, evidence of specific instances of a victim's sexual behavior with respect to the person accused of the sexual misconduct if offered by the defendant to prove consent or offered by the prosecutor, and evidence whose exclusion would violate the defendant's constitutional rights. The last two is pretty much self-explanatory. The Federal Rules of Evidence 412B, if a defendant intends to introduce evidence of a victim's other sexual behavior or alleged sexual predisposition under one of these exceptions, the rule requires the filing of a sealed motion no less than 14 days before trial that specifically describes and states the purpose for which it is to be offered, with notice to the victim or her representative. Federal Rules of Evidence 412C1. None of the limited exceptions to Rule 412 apply in this case. Kelly is charged with enticing each of the minors named in the indictment to engage in sexual contact and acts with them repeatedly over the course of years. Here, any evidence of a victim's sexual behavior with anyone other than Kelly or others at Kelly's direction, as well as any evidence of any purported sexual predisposition, would be wholly irrelevant to the charges against the defendant. The exclusion of evidence on these topics is thus appropriate under Rule 412. Reference. The 10th Circuit in 2019 held that prosecution affirming district court's decision to prohibit the introduction of evidence suggested of the minor victim's sexual predisposition and her previous sexual activity with a male depicted in photos on her phone. B, evidence is inadmissible under Rule 403. Even if evidence concerning the victims of sexual conduct was relevant, it is not. Any probative value would be marginal at best and substantially outweighed by the dangers of unfair prejudice, confusion of the issues, misleading the jury, and embarrassing the victim, and it should be excluded pursuant to Rule 403. And when they say probative, that just means something that evidence that proves the charges, right? Proves the, who the, in this case, the prosecutor's, side of the case, right? So that's what that word means. In particular, such evidence would provide for the substantial risk that the jury will question the victim's sexual morals and view them as untruthful because of their prior sexual activities. For all of these reasons, any inquiry or evidence related to the victim's sexual history is properly excluded under Rule 403. Number 3, motion to bar evidence and argument related to consent. And I hate to keep stopping, but I'm glad that we're going through this, and I'm glad we're getting a detailed motion, because this will help. This will help y'all to understand that you just can't come in there all willy-nilly and put everything in there, do what you want or whatever. All right? Because you see, you have all these exclusions, right? Unless it's an exception to the rule. If it's an exception to the rule, then it may be allowed in, right? It may be admissible. Okay. So let me say that again. Motion to bar evidence and argument related to consent. The government requests that the court prohibit defendant from introducing evidence and arguing that the minor victims consented to engaging in sexual activity while they were minors. Now, how the prosecutor is preparing this, either one, they have some kind of information that the defense may try this particular defense, or two, they're just preparing, right, for anything that may come up, because with certain cases, there are certain defenses that's almost a given, right? So the prosecution could be doing one or two things or both, but they are right now, they're saying that they are barring any testimony, any evidence that says that the victims consented to engaging in sexual activity while they were minors. And we already know that you can't do that anyway, right? Because, and if that evidence is allowed, that can confuse the jury. And evidence that confuses the jury is often objected to. It is well established that minors lack the capacity to consent, and so sexual contact with a minor is always without consent. Okay, we say that all the time over here. All right, case law. We have the 8th Circuit in 2008 affirming the district court's exclusion of consent evidence as irrelevant in a prosecution under 18 U.S.C. section 2251A. Case law. Because the district court was correct as a matter of law that consent is not a defense to the crimes charged, it was not an abuse of discretion to exclude the consent evidence. Case law. That the minor consents to engaging in prostitution is not a defense to the crime of trafficking a minor for purposes of prostitution. So that pretty much makes sense as stated, right? If she's a prostitute, and although she's under the age of 18, that's still not a defense, because that's still not consensual, right? Even though she's selling it. Okay. In Rafflinger, the defendant was charged with sexual exploitation of a minor in violation of 18 U.S.C. section 2251A, and E, distribution of child pornography in violation of 18 U.S.C. section 2252A, A1 and B1, and possession of child pornography in violation of 18 U.S.C. section 2252A, A5B and B2. The defendant agreed that consent was not a defense to the distribution of possession of child pornography charges. However, at trial, he sought to introduce evidence of the minor's consent as to the sexual exploitation charge. Specifically, the defendant sought to introduce evidence that the minor victim consented to engage in sexual behavior and lascivious exhibition. 555 Federal 3D at 692. On appeal, the 8th Circuit rejected the defendant's argument that such evidence should have been admitted and concluded that because the district court was correct as a matter of law that consent is not a defense to the crimes charged. It is not an abuse of discretion to exclude the consent evidence. So apparently, the defense tried to get it must be did an appeal in that particular case with regards to the judge's evidentiary rulings, and that's what they came back with. The Eighth Circuit further held that the jury was properly instructed that a minor may not legally consent to being sexually exploited. The Ninth Circuit's decision in United States versus Dingra, Ninth Circuit 2004, is also illustrative. The defendant charged with enticement of a minor in violation of 18 U.S.C. Section 2422B proposed a jury instruction that would have required the jury to acquit him if it found that the victim induced him and was at least partially willing to engage in the alleged sexual conduct. Oh, okay, wait a minute, we can talk about this. The trial court refused to give the instruction. In affirming the defendant's conviction, the Court of Appeals wrote, let's see what they wrote. The defendant's argument collapses because he misconstrues the nature of the liability under Section 2422B. His proposed jury instruction reflects this mistake. In effect, the defendant claims that entrapment by the victim ameliorates any inducement on his parts, and ameliorates means that it makes something bad better, right? Again, this reading of the statute mistakenly changes the focus from the defendant to the victim. The victim's willingness to engage in sexual activity is irrelevant in much the same way that a minor's consent to sexual activity does not mitigate the offense of statutory rape or child molestation, so long as the defendant's action constitutes the act of persuading, inducing, enticing, or coercing a minor to engage in criminal sexual activity. Section 2422B applies. So where have we seen this type of argument before, right? We saw this with J-Bo in New York, right? In her post-conviction filings, right? But look what the prosecutor in this case says. Look how they came back with something that speaks perfectly to this particular situation. So remember, J-Bo was trying to introduce those text messages to show that it was R. Kelly that was being induced, enticed, persuaded, and coerced, right? Rather than the other way around, that the elements speak of, right? That they convicted him on, okay? So I don't recall the prosecutors, as smart as they are in New York, coming back citing this. But you know what we're going to do? We're going to go find it and see if they cited that. So we're going to look. Hold on, let me write that down. The Court of Appeals wrote. Let me see. What was this? In United States versus. All right. Because that perfectly addressed J-Bo's situation with her same argument with regards to those text messages in the New York case. Remember, on her acquittal. This was answered. This was affirmed by the Court of Appeals, meaning it went up the chain, all the way to the appeals court. And that's what they said. The defendant's argument collapses. And it was, I think, for the same charge, 18 U.S.C. Section 2422B. Yeah, so we're going to see if the prosecutors in New York answered the same, used the same reference, same case law. We're going to see. Let's see. In United States versus Dye, a reference. Let's see. The Third Circuit in 2010, the Third Circuit rejected a similar argument. In that case, the defendant was charged with enticing a minor in violation of 18 U.S.C. Section 2422B and traveling interstate for the purposes of engaging in illicit sexual conduct in violation of 18 U.S.C. Section 2423B, which Levi and I spoke on this shit this morning in this morning's live. Remember the sexual aspect and the traveling? Levi, I think they listening to us. Levi, this some bullshit. No, I'm just joking. At trial, he admitted to the conduct alleged, but argued that the government evidence against him was insufficient because the purported minor was a seductress who had persuaded, induced, and enticed him, and not the other way around. Shut up, him. Shut up. Don't fuck with us. Don't fuck with us over here. Don't do it. Don't do it. It only make you look stupid and silly when you do your breakdown. Don't fuck with us over here. Let's see what happens. The Third Circuit rejected this defense. Okay, we got another rejection. The defendant's hot to trot defense is especially troubling because its underlying premise is that it is possible for a 14-year-old child to seduce a 36-year-old man, absolving the man of criminal liability for engaging in or attempting to talk the minor into engaging in illicit sexual activity. The defendant cites no case law, however, to support the notion that minors who are by law unable to even consent to sexual activity, case law, can ask for it in such a way that it becomes legally permissible for adults to entice minors into sexual escapades. So we already know, we get ahead of the game here, right? So we already know that if she kicks this up to just assuming that Ann Donnelly, denies it, right? She kicks these matters up to the Court of Appeals. Well, they already have decisions from higher courts. Okay? We see it here. So, I don't have to say to you what probably is going to happen in New York. Okay? Hey, y'all got to be able to hang. We work out of two brains, two goddamn sides. We work out of two cases all at one time. We do it all, goddamn it. I ain't on the screen, so I don't know what y'all saying. So, y'all know when I get excited, I get tight-tongued and all fucked up. So let me calm down. In this case, consent is not a defense to the charges in counts 1 through 4 and 9 through 13 of the superseding indictment. Whether any of the minor victims allegedly agreed to engage in sexual conduct with or at the direction of Kelly is irrelevant to whether Kelly is guilty of violating sections. Remember when I say you see the double S's, two of them? That means it's two sections, right? It's 2251A or 2422B. That's when you're reading it, so you'll know how to read it properly. Okay. Therefore, evidence and argument related to the victim's consent is irrelevant and should be excluded at trial. This includes questions during cross-examination of the victims about whether they consented to having sex with Kelly or others while they were minors. Such questions would call for witnesses to make legal conclusions and should be barred. For all of these reasons, the court should grant the government's motion to bar evidence and argument related to the minor victim's consent. The government will offer instructions on this issue and its proposed jury instructions to be submitted at a later date. All right, so here you see that the government is also trying to do what? Shut down defenses, okay? They're trying to shut them down. Number 4, Motion to prevent the public display of child pornography videos during trial. And also, you wouldn't know that that's what they're trying to do, so unless you went to school for this, or you know how to read what's written and what's not there. Okay, you have to know how to decipher both. Number 4, motion to prevent the public display of child pornography videos during trial. The court should prevent the publication of child pornography video clips to the gallery during trial. There is no doubt that criminal trials are public events and that the weighty concerns about the fairness and integrity of the proceedings require that criminal trials be open to the public. Case law. The presumption of openness in criminal trials is not absolute. However, in United States versus Gupta, the presumption of openness may be overcome by only an overriding interest based on findings that closure is essential to preserve higher values and is narrowly tailored to serve that interest. Here, the overriding interest is the protection of minor one, who is depicted in the child pornography videos that the government intends to introduce at trial. The Supreme Court has found that child pornography creates a permanent record of a victim's abuse, and the very existence of that child pornography causes the child victim to continuing harm by haunting the children in years to come. Osborne versus Ohio. Victims of child pornography often write about their ongoing anxiety and fear that people who see them in public places will recognize them from the photographs that were taken of them as they were exploited. Reference. The National Center for Victims of Crime at 7, available at that website. Although the children cannot control that these images exist, this court can prevent the images from being publicly displayed during trial. The government has narrowly tailored its request to serve the victim's interests. The only accommodation that the government seeks for the court to limit publication of sexually explicit videos to the jury and trial participants while avoiding publication to the gallery. The government is not asking for any limitation on testimony describing such images. Requests to limit publication of child pornography are commonly granted. Case law. In Northern District in Indiana, on August 31st, 2012, stated that limiting display of child pornography images to the jury and trial participants and finding that there is no particularly compelling reason why the public would need to see child pornography in the gallery during trial, and it would be detrimental to the minors depicted therein to put their victimization on display. In United States versus Sepman, this court granted the government's motion to prevent the public display of child pornography images and clips during the trial in that manner. Reference. Should they referring to they're referring to Judge Lindweber case. Further preventing the display of child pornography images to the public does not constitute plain error. Case law. The Second Circuit 2015 found that no plain error, where even assuming that restricting the display of trial exhibits to the courtroom audience constitutes a partial closure for Sixth Amendment purposes. The government presents substantial reasons for doing so, limiting the continuing harm to victims of child pornography. Hold on for a minute. Let me shut this shit down because I don't know what the fuck is going on with this. Oh man, what is going on? Goddamn. Damn burner phones and shit. Okay. Okay, United States versus Boyle. Oh my God. Versus Boyle. Finding no plain error was where district court permitted the government to turn off a monitor facing the gallery during the display of allegedly sexually explicit images. Number 5, government's intended evidence of polygraph examinations. Whoa, okay. At trial, the government will present evidence about polygraph examinations that were administered for multiple witnesses who were involved in the recovery of videotapes produced by Kelly containing child pornography. A. Factual background. In summary, Count 5 of the superseding indictment alleges that between 2000 and 2019, Kelly and McDavid conspired with each other, individual A and others, to conceal and cover up the existence of multiple videos depicting Kelly engaged in sexual contact and sexual acts with minors. Reference 93. Superseding indictment, counts 5, 2 through 5. In approximately 2001, Kelly and McDavid learned that at least 4 of these videos, video 1, 2, 3, 4, were missing from Kelly's collection of child pornography. In order to conceal and cover up the existence of videos from investigators, Kelly, McDavid, and others agreed to collect the missing videos that depicted Kelly engaged in sexual contact with minors. It is alleged that Kelly and McDavid paid hundreds of thousands of dollars to individual A, B, C, D in exchange for obtaining and returning multiple videos that they knew depicted Kelly engaged in sexual contact and sexual acts with minors. Wow. 6. As a condition of being paid money for returning the videotapes, the superseding indictment alleges that Kelly and McDavid directed individual B, C, and D to take polygraph examinations regarding whether they had returned all copies of such videotapes. The indictment further alleges that at the direction of McDavid on Kelly's behalf, okay, remember the 3 B's, on at the behalf, and the benefit. Okay, so you got the behalf right here. Individuals C and D took polygraph examinations regarding the videotapes that individuals C and D had returned depicting Kelly engaged in sexual contact and sexual acts with minor 1 and individual D, including whether there were additional copies of the videotapes. At trial, the government will call individual B, C, D to testify about their involvement in the conspiracy to recover and return videotapes to Kelly and McDavid depicting Kelly's sexual abuse of minor 1. Individual B, C, D would testify about the communications they had with the defendants about returning the tapes in exchange for financial compensation. They will testify about how, as a condition to receiving the promised payment, they were required to first take a polygraph examinations about whether all such videotapes had been returned to Kelly and McDavid. Wow. Hold on, y'all. Let me adjust my back. Oh, shit. Honey, I got every bell in the world going on. Okay. The government also plans to call on or more of the polygraph examiners to testify. Oh, shit, they got the polygraph examiners to testify about their involvement in administering the polygraph examinations of individual B, C, D. Through these witnesses, the government will introduce testimony and documents related to the polygraph examinations that were administered on behalf of Kelly and McDavid. The documentary evidence, which is described further below, is relevant to the charged conspiracy in that it demonstrates that the witnesses were subject to such examinations about the videotapes as a condition to their promised payment from Kelly and McDavid. For example, the government anticipates that individual D will testify that in 2007, she was required to take 3 polygraph examinations geared at determining whether she had returned all copies of a videotape that she took from Kelly that depicted individual D having sex with Kelly and minor 1. That's on video 4. Individual D will testify that after passing the first 2 polygraphs, she received payments from McDavid and Kelly. In order to get the remaining money that she was promised by Kelly and McDavid, individual D had to take a 3rd polygraph examination. Oh my gosh. The government seeks to introduce documents related to individual D's polygraphs, including, Lord have mercy, dated consent forms signed by individual D in which she agreed to take the polygraph examinations and release the results to Kelly's attorney at the time, pre-examination interview forms completed by the examiner containing some general background information about individual D, the examiner's notes listing the questions that he asked individual D during the polygraph examination. Wait a minute, y'all. Wait a minute. Y'all, wait a minute. Okay. Now, this is getting out of hand. This is evidence that is also inextricably intertwined. It's evidence, corroborating evidence. It's backing it up. Not only do you have they have the polygraph examiners. Like, this is crazy. Now, don't get this confused with the polygraph test that is generally not allowed in court, because in some cases those regular polygraphs are. This polygraph is coming in as evidence of a crime, right? These are additional acts. Okay? These are additional acts. So it's not coming in as a regular polygraph that they can argue whether it should be admissible or not. No. This is coming in as acts. Okay? This is a behavior that's coming in. Okay, these documents are relevant to show the dates that the polygraphs were administered, who administered them, and who would receive the results of the exams. In particular, the questions that were asked during the examinations are relevant to establish the purpose of the polygraph examinations. Remember, it's the acts. As another example, the government plans to call individual C to testify about how individual D sent him a copy of the videotape that she took from Kelly containing the video of Kelly, individual D, and minor 1 having sex. After individual C received the tape, he was summoned to Chicago to meet with David about returning the tape. Oh boy, David, baby, you all hooked up in this. So, wow. So now, so I'm gonna tell y'all what's going on. You know, I'm gonna keep it funky with you. Now, this is more than McDavid just being hooked up to the money, right? Because you can make a pretty good defense that, okay, well, he was in charge of R. Kelly's money and all of this for 15 years, and R. Kelly didn't know about his finances, and he illiterate and whatever. But now you're tying McDavid to physically meeting someone by the tape that's depicting allegedly R. Kelly in some illegal acts. Hmm. Shit. Wait a minute. Where was I? Okay. Hold on 1 minute, y'all. Let me see what that was to the door. Hold on 1 minute. I'll be right back. So they have now tied him. So now we know that they're tying him to physically being in this whole like this tape shit. So it's more than just the money shit, right? Which I mean, like I think the indictment stated like um McDavid, as much as I can remember, it's like he was in on the financial part, like he was cutting the checks or whatever. But they are laying out that he met with these people and all of this here and all of that, and yeah. So it's getting it's getting up there now. And shit going on now. Let me go back and so let me start that over. As another example, the government plans to call individual C to testify about how individual D sent him a copy of the videotape that she took from Kelly containing the video of Kelly, individual D, and minor 1 having sex. After individual C received the tape, he was summoned to Chicago to meet with McDavid about returning the tape. Individual C is expected to testify that before he left for Chicago, he made a copy of the full-length tape and only brought a shorter snippet of the tape with him to Chicago. According to individual C, once he arrived in Chicago, he provided the snippet to McDavid, who went into another room with individual D. When McDavid returned, he told individual C that he would have to take a polygraph examination. Individual C will testify that after he took the polygraph and failed, McDavid instructed individual C to go home and get the original tape or else someone would come visit him. Oh, Lord. Threats? Individual C understood McDavid's statement to be a threat. Oh, shit. Oh, okay. Individual C will further testify that before he left that day, McDavid paid individual C $20,000 in cash as a down payment for going back to get the original tape for McDavid and Kelly. Let me make sure I took the damn mute off. Okay, I did. Shit, I done got so goddamn shook. I can't remember. All right, the government anticipates that individual C will testify about the events that occurred after he returned to Chicago with the original tape. Specifically, individual C is expected to testify that he was required to take another polygraph examination about whether he had any other copies of the tape. According to individual C, he passed the second polygraph and McDavid paid individual C $80,000 in cash. The documents created as a result of individual C's polygraph examinations included the consent forms that individual C signed and the examiner notes regarding the administration of the polygraphs, confirmed individual C's trip to Chicago, and meetings with McDavid, and are direct evidence of the conspiracy to conceal and cover up Kelly's sexual abuse of minors. Whoa. B. Argument. In this case, defendants use polygraph examinations as a tool to further their conspiracy to obstruct justice and recover illicit videotapes of Kelly engaged in sexual contact with minor 1. During the conspiracy, defendants retained multiple examiners to administer polygraphs to multiple witnesses in this case. What is that? What is it? Hold on, y'all. This is driving me crazy. Okay. Many of whom were subjected to more than one polygraph. This evidence demonstrates how serious defendants were about recovering the missing child pornography tapes and is admissible to show consciousness of guilt. The government seeks to introduce evidence and testimony about the polygraph examinations for purposes wholly unrelated to the substantive correctness of the results of the polygraph examination. The government will not elicit testimony from witnesses about whether the results of the tests were scientifically accurate. Okay, so you see how they broke that out? So they're telling you it's not coming in. They're not trying to admit a regular polygraph, as normally polygraphs are generally not admissible unless both parties agrees, or some there's some other reason why it should be admitted, right? They're telling you that it's coming in as a part of the conspiracy. So it's the acts. Okay? The purported results are only relevant insofar as they provide important context as to, 1, why McDavid required individuals to take multiple tests, and 2, why McDavid paid large sums of cash to individuals after it was reported that they passed the examinations. Wait a minute. Okay. The government further represents that it will not use the results of the polygraph to bolster the credibility of any witness and will not make any arguments regarding the scientific reliability of polygraph examinations at trial. So that's just pretty much saying they're not going to go down the line of questioning that's generally associated with polygraphs that are admissible, right? So they're not admitting them. I told you they're not admitting them for the reasons general polygraphs are admitted if they are admissible. Okay, this is for the acts. Okay, it says admission of the polygraph evidence for the limited reasons set forth above is permitted under Seventh Circuit law. The Seventh Circuit has given district courts considerable deference on the issue, indicating that the decision to admit polygraph evidence will be reserved only when the district court has abused its discretion. Case law. It says 7th Circuit in 2016 in Resnick, the government presented evidence that during the execution of a warrant on the defendant's home, law enforcement asked the defendant to take polygraph examination, and defendant refused to take one. In affirming the court's admission of this evidence at trial, the 7th Circuit reasoned that this case is not in the end about polygraph evidence. It is about the evidence of a refusal to take a polygraph. The same principle applies here. The government is not seeking to use the results of the polygraph examination for their scientific value or to bolster the credibility of any witness. Rather, as alleged in the superseding indictment, Kelly and McDavid caused examiners to administer polygraph examinations in furtherance of their conspiracy to obstruct justice. It is also important to highlight that the offered polygraph evidence does not relate to polygraphs of any of the defendants in this case. As a result, there is no risk that the jury could make adverse inferences about the defendant's credibility, as the government is not offering evidence that any of the defendants took polygraphs. Case law. The 9th Circuit in 1988 affirmed exclusion of evidence that defendant took a polygraph under Rule 403 because even if the facts about an exam were admitted without the results, the jury would still be reasonably likely to infer that defendant failed the polygraph. In sum, evidence of where, when, how, and why the polygraphs of individual B, individual C, and D were administered is probative evidence of the conspiracy charged in the indictment, including, for example, one of the alleged overt acts that McDavid, acting on Kelly's behalf, directed individuals C and D to take polygraph examinations, and as such, this evidence should be admitted at the trial. So I told you it was for about the acts. That's why they're trying to get it in. And right there it says, including, for example, one of the alleged overt acts. Okay. Number 6. Notice regarding introduction of the false records alleged in the superseding indictment. The government provides notice that it will seek to introduce certain false records alleged in Court 5 of the superseding indictment. First, the government provides notice that it will seek to admit a memorandum summarizing an interview of individual D that took place on about July 26, 2007. This memorandum, which is not hearsay, is relevant to prove that McDavid and Kelly conspired to obstruct justice as alleged in Court 5 of the superseding indictment. Okay, so here you see that they seek to get a, what is this? An interview from individual D. So we assume that's who that is. What name is? Van Allen. And so they're going to use media, okay, an interview. Particularly relevant to this motion is the allegation in the superseding indictment that on or about July 26, 2007, Kelly and McDavid directed individual D to falsely deny that individual D and Kelly engaged in sexual acts together with minor 1, when Kelly and McDavid knew that Kelly had engaged in sexual acts with minor 1 and individual D. As Kelly and McDavid intended, a false record, document, and tangible object was prepared based upon individual D's false statements. Reference 93, count 5 and 7. The memorandum of individual D's interview is the false document referred to in the superseding indictment. And let me tell you something else I picked up. They keep attaching McDavid's name to Kelly's name. Why do y'all think they're doing that? Now, I'm pretty sure they're going to get to Brown. But why do you think that? I'm going to come around the front and I'm going to see. I don't mean to keep stopping like this, but why do y'all think that they keep attaching McDavid's name and Kelly's name through this document so heavily like this? Anybody want to take a shot at it? The Enterprise is in New York. What is the big deal that's going on between McDavid and Kelly? That severance. And see, the government is showing without saying, without, taking an extra opportunity, because they've already taken their opportunity, right, to answer that severance. But right now in this motion in limine, they're showing why McDavid and Kelly should be tried together for real. They all three of them should be on trial together because it's showing how closely they were all intertwined in this particular shit, right? What they allege, right? So they're taking another shot to showing the judge, hey, judge, look, we can link McDavid to Kelly all through this shit with this conspiracy, this obstruction, and all of this. Yeah. To keep them together. And seeing this, why you have to get a sense of your prosecutors, your defense, and your judge if you can, right? Because if you're trying to break this down and analyze it, you got to get a sense of how they get down, right? It says, as set forth, individual D was summoned to Chicago multiple times in 2007 in connection with McDavid and Kelly's effort to collect contraband videotapes and impede the Cook County criminal prosecution in 2008. Individual D was required to take multiple polygraph examinations to assure Kelly and McDavid that she had returned the video she took from Kelly that depicted herself, Kelly, and minor one engaging in sex acts while minor one was around 14 years old. Individual D is expected to testify at trial in this case that following her third polygraph examination on or about July 26, 2017, McDavid told her to meet with other lawyers and tell them that she never had sex with minor one. Individual D is expected to testify that McDavid waited in the hallway as she went in the room to meet with the lawyers and provide them with the false statements as instructed by McDavid. A memorandum of interview dated July 26, 2007 was prepared documenting individual D's false statements. In summary, the memorandum states that individual D provided the following information. Between 1997 and 2006, individual D had sex with Kelly and multiple other females, all of whom were over the age of 17. Individual D knew minor one and had spoken to her on numerous occasions. Individual D never saw Kelly in a sexual situation with minor one. Minor one was never a participant in any sexual encounter with individual D and Kelly. Individual D agreed to be interviewed by attorneys on July 26, 2007. Individual D was not forced, threatened, or promised anything to participate in this interview. At trial, the government will question individual D about this memorandum, and the lay wait a minute, memorandum, and the laid the foundation. They must meant, and they laid the foundation for the memorandum's admission into evidence. The memorandum should be admitted as the statements therein are not being offered for their truth. Okay. Okay, so that if it's not being offered for the truth, there must be being offered to show the obstruction or the conspiracy or something. Let's see. Quite the opposite. The government seeks to use this document as evidence to show that she was coerced by McDavid and Kelly to provide false information about her knowledge of minor one and Kelly's abuse of minor one. The government's evidence will further show that on or about July 26, 2007, individual D received a $30,000 payment from McDavid. Right. So that's evidence of the conspiracy or obstruction. All right. So in addition, the memorandum is not privileged. After the memorandum was prepared, Kelly's attorney at the time provided the memo to the assistant state's attorney assigned to Kelly's criminal trial in Cook County. The Cook County State's Attorney's Office in turn provided a copy of the memo along with the correspondence from Kelly's attorney to the United States Attorney's Office, and the memo has been produced to the defendants in this case. Second, the government provides notice that it will seek to admit a police report containing false information provided by minor one during the Chicago Police Department's investigation of Kelly in 2000. The fuck? This shit was not okay. I don't know how many times I gotta cut these goddamn phones off. This is crazy. As alleged in the superseding indictment in approximately December 2000, pursuant to instructions that minor one received from Kelly, minor one falsified and caused a false entry to be made in a police report when minor one denied to law enforcement officers that Kelly engaged in a sexual relationship with minor one. Reference 93, count 5 and 7. At trial, minor one is expected to testify that Kelly began having sexual contact with her beginning around 1997 or 1998, when minor one was 13 or 14 years old. When minor one was about 15 or 16 years old in about 2000, certain government agencies began investigating allegations that Kelly was sexually abusing minor one. Kelly introduced minor one on how to act and what to say if she was questioned. Now, see, this is what I was telling y'all. I don't know why the prosecution still has a date range and an age range. If you got evidence, meaning videos, or you got all this, whatever they have, and you're saying that he had sex with her when she was underage, which 13 or 14 is still underage. But see, you're going to get, if they don't button down a date, a year at least, and an age, that's going to give the defense an opportunity to say, well, hey, how can you say that this evidence is to be believable or trusted, or it happened as you said, when you said whatever, if you can't give us a date, whether it was 1997 or 1998, it's a big difference between 1997 and 1998, or whether she was 13 or 14. The prosecutor, to me, this is my opinion, will have to have some type of excuse as to why they don't have the exact date. Because if you have a piece of evidence saying something happened exactly on that particular date, when she was a certain age, all of us being underage, then you should, you're gonna give the defense a little opening to challenge that, to challenge the credibility of the evidence. that's outside of challenging whether the tape is being manipulated, edited, challenging the timestamps, and all of that, challenging who's actually depicted in the video, and those are normally the objections, the challenges to videotape evidence, right? That type of digital evidence. But you got those dates. So you got beginning around 1997, 1998. I mean, shit. Okay, in or around December 2000, law enforcement officers from the Chicago Police Department questioned Minor One about sexual contact with Kelly. During the interview with CPD, Minor One falsely denied the allegations of Kelly's sexual misconduct and documented that information in a police report. In summary, the police report states that law enforcement interviewed Minor One, who stated that she had never been sexually abused by Kelly and that any such allegations are untrue. At trial, the government will seek to admit the CPD report into evidence. Admission of this report is permissible as it is not hearsay and is being offered to prove allegations in the superseding indictment. So that evidence is offered to prove the truth of the matter, right? Therefore, you can allow hearsay in that particular instance. Okay, for all these reasons above, this described record should be admitted into evidence. Number 7, government's notice of intent to admit direct evidence of crimes charged. Oh boy, direct evidence. God damn. And this is another case where they got damn near every type of evidence represented. I'm just being honest. This is crazy. I need to wipe my head off with something cool. All right. As set forth in the superseding indictment, Kelly is charged with multiple crimes relating to his sexual abuse and exploitation of 5 minors over the course of several years. Count 1 through 4, 6 through 13. The indictment further alleges that McDavid knew that Kelly was sexually abusing minors and that Kelly made several videotapes documenting the abuse. Count 5. You see how they dragging McDavid's name in here? That's for a reason. Kelly and McDavid went to great lengths to cover up the abuse, including paying large sums of money to witnesses to ensure that they would lie to law enforcement about criminal conduct. In furtherance of Kelly and McDavid conspiracy to obstruct justice, it is alleged in the superseding indictment that Kelly used physical abuse, violence, threats of violence, blackmail, and other controlling behaviors against victims so that Kelly could maintain control over them, prevent them from providing evidence to law enforcement, and persuade them to continue to abide by prior false statements relating to Kelly's sexual contact and sexual acts with minors and videos of such conduct. At trial, the government will introduce testimony and evidence of the physical, emotional, and sexual abuse that Kelly inflicted on minors 1, 3, 4, 5, and 6 over the course of several years. The victims will testify about how Kelly used violence and threats of violence to control, manipulate, and isolate them, all as a means to coerce the victims to have sex with Kelly and prevent them from reporting Kelly to the police. For example, the government expects that Minor One will testify that Kelly began hitting her when she was around 17 or 18 years old. Minor One will also testify about how Kelly isolated her from her family and friends and controlled her every move, including who Minor One was allowed to talk to. Another example, Minor 5 will describe the strict rules that Kelly had regarding who minor 5 was allowed to speak to, and that minor 5 had to seek Kelly's permission before interacting with other men. Wait a minute, wait a minute. Okay, minor 1 got B. Okay. Have strict rules. Okay. All right. According to minor 5, there was one instance where Kelly punched a man after he told minor 5 that he thought minor 5 was cute. Oh. Okay. All right, Kelly knocking people out. Kelly got a little jealousy. Oh, knock the man out. Okay, wrong. Shit. In short, Kelly used physical violence and emotional manipulation to entice and coerce the victims to have sex with him. Thus, testimony about how Kelly hit or otherwise inflicted physical violence against the victims is direct evidence of Section 2422B charges. Evidence, and now remember, if anybody want to look at it, remember I told y'all that physical abuse, domestic violence can be stuck in sexual abuse, but sexual abuse cannot be stuck in domestic violence. Remember I told y'all that? So let me see. I'm pretty sure 18 USC is that sexual abuse charge, but let me make sure. $24. We should know that by heart by now. Okay, what's the B? Coercion and enticement. Wait a minute. How they getting that out of that? Okay, wait a minute. Ensure Kelly physical violence, emotional manipulation to entice and coerce victims to have sex with him. Thus, the testimony by Kelly hit otherwise inflicted physical violence against the victims are direct evidence of it. I'll come back to that. Evidence of Kelly's physical abuse is also direct evidence of the charged conspiracy to obstruct justice, which alleges that between approximately 2000 and 2019, Kelly used physical abuse, violence, threats of violence, blackmail, and other controlling behaviors against victims so that Kelly could maintain control over them, prevent them from providing evidence to the law enforcement, and persuade them to continue to abide by prior false statements relating to Kelly's sexual contact and sexual acts with minors and videos of such conduct. Reference 93, count 5, 9. As a result, minors' one testimony about Kelly's physical and emotional abuse of her while she was an adult is also direct evidence of the Section 371 charge. Number 8, motion for prior notice concerning Rule 608B, impeachment. Okay, this should be interesting. The government moves to bar each party from introducing evidence, including by asking questions on cross-examination under Rule 608B, except upon prior notice to the court and the opposing party outside of the presence of the jury. Rule 608B provides that specific instances of past conduct may be inquired into may be inquired into on cross-examination if and only if they concern the witness's character for truthfulness. By its very nature, impeachment based upon a witness's prior conduct that is not relevant to the matter of issues creates risk of causing unfair prejudice to an opposing party. First, a party attempting to conduct such impeachment may erroneously believe that such impeachment is appropriate when it is not, the end result being the impropriety of the impeachment is only discovered after the disparaging impeachment conduct is presented to the jury as part of an attorney's question. Second, even if some conduct may properly fall within the scope of Rule 608B, counsel may exceed any limitations on the scope to which such matters may be addressed on cross-examination. Third, depending on the nature of the past conduct raised by the examiner, the jury may not be able to completely obey the court's instruction to disregard the contents of an improper question heard by the jury. For these reasons, and to avoid any risk of unfair prejudice, the government asks that this court exercise its discretion to preclude the parties from pursuing any impeachment under Rule 608B unless, outside the presence of the jury, the party has made a prior offer of proof concerning the alleged prior conduct. See Federal Rules of Evidence 611. The court should exercise reasonable control over the mode and order of examining witnesses and present evidence so as to, 1, make those procedures effective for determining the truth, 2, avoid wasting time, and 3, protect witnesses from harassment or undue embarrassment. Procedurally, the government proposes that prior to cross-examination, the court should require each party to first notify the court and other parties at sidebar of its intent to impeach under Rule 608B. This procedure would ensure that any alleged prior bad acts are not improperly communicated to the jury before the court has the opportunity to determine whether such alleged prior bad acts are the subject of proper impeachment under Rule 608B. Number 9, motion to preclude argument or evidence designed to elicit jury nullification. Oh, wow. The government moves this court to preclude the defendant from arguing or otherwise present evidence or pursuing lines of inquiry designed to elicit jury nullification. It is well settled that it is improper for a defendant to suggest in any way that the jury should acquit defendant, even if it finds that the government has met its burden of proof. Case law. The Seventh Circuit in 2012 held that the court held that district court properly found that evidence offered by the defendant was irrelevant and served to only confuse the jury or invite the jury to acquit, even if the government satisfied each element of the offense. Remember this morning I was talking to Levi about evidence that only, confuses the jury and stuff like that. They don't usually allow that. Let's see. Case law. In this Seventh Circuit in 1996, an unreasonable jury verdict, although unreviewable if it is an acquittal, is lawless, and the defendant has no right to invite the jury to act lawlessly. Jury nullification is a fact because the government cannot appeal an acquittal. It is not a right either of the jury or of the defendant. And that's United States versus Sepulveda in the First Circuit in 1998, holding that the court may block defense attorneys' attempt to serenade the jury with the siren of nullification. Therefore, the defendant should be precluded from presenting arguments or evidence designed to elicit jury nullification. I wonder why they're going on and on about that. Okay. Let's see. The government cannot anticipate each form of potential jury nullification, argument, or evidence. The government moves to exclude the potential areas noted below, all of which are irrelevant to the elements of the crimes charged, as well as any argument or questioning, no matter what its form, that in effect would encourage a jury to acquit under circumstances regardless of the applicable law or proven facts. And then you have case law. Well, why they keep arguing about jury nullification? I don't know. Block defense attorney attempt to serenade. I don't know why they keep arguing about that. All right. A. Motion to preclude argument or evidence concerning potential penalties faced by defendants if they are convicted. Motion to preclude argument or evidence concerning potential penalties faced by defendants if they are convicted. Okay. The government moves the court to preclude defendants from introducing evidence, making argument, or otherwise mentioning the potential penalties faced if convicted. For one, the Seventh Circuit pattern criminal jury instructions include an instruction specifying in deciding your verdict, you should not consider the possible punishment for the defendant. If you decide that the government has proved the defendant guilty beyond a reasonable doubt, then it would be my job to decide on the appropriate punishment. Right? That's a reference. Additionally, the Seventh Circuit has stated that arguing punishment to a jury is taboo. Wow. Seventh Circuit, 1997, vacated on the grounds the practices of informing juries about the sentencing consequences of their verdicts is strongly disfavored, right? Case law. The Seventh Circuit in 1991 holding that while the Sixth Amendment requires that a jury determine questions of guilt or innocence, punishment is the province of the court. Argument and evidence concerning punishment are improper because the law is well settled that the potential penalty faced by a defendant is irrelevant to the jury's determination of guilt or innocence. Case law. It is well established that when a jury has no sentencing function, it should be admonished to reach its verdict without regard to what sentence might be imposed. Let's see. Case law. God damn, it's heavy. The Ninth Circuit of 1991, it has long been the law that it is inappropriate for a jury to consider or be informed of the consequences of their verdict. Mention of the potential penalties faced by a defendant only would serve the improper purpose of jury nullification. God damn. The authorities are unequivocal in holding that presenting information to the jury about possible sentencing is prejudicial. According to the defense, juries should be precluded from mentioning or introducing evidence about any range of the penalties faced if convicted. We got motions to preclude allegations of outrageous government conduct. Well, goddamn. The government moves to exclude evidence or argument by counsel of outrageous government conduct. The Seventh Circuit repeatedly has held that the outrageous government conduct is not a defense in this circuit. Case law. The Seventh Circuit in 2001, Seventh Circuit, 1995, outrageous government misconduct is no defense to a criminal charge, and the jury thus should not be exposed to irrelevant allegations of this sort. Furthermore, the circuit held that the issue of government misconduct was a matter of law for determination by the court. The issue of government misconduct is not an issue for the jury. Case law. The Seventh Circuit in 1987, noting that every circuit which has considered the issues has held that the issue is not a jury question. Yet, there is a tendency in criminal cases to try some people other than the defendant and some issue. Wait a minute. Why is this written like this? Yet there is a tendency in criminal cases to try some person other than the defendant and some issue other than his guilt. Case law. The thrust of the defense in these types of cases is this: the prosecution was not nice or could have done it better, and so the jury ought to acquit whether or not guilt has been proved beyond a reasonable doubt. And that's jury nullification. Trying to acquit someone when you know that when the jury knows that they have broken the law, right? That's what that means. In the face of this tendency to interject themes of the government misconduct into a defense strategy, courts routinely have granted motions in limine to bar defendants from presenting evidence or making arguments to the jury suggesting that they should be acquitted because the government engaged in misconduct in the course of its investigation. So let me tell you what's going on right now. With the last three sections I read, what they're trying to do is box Bonjean in, right? They're trying to remove a whole bunch of her defenses. And they're stating reasons why. They're backing it up with higher court decisions. So, and they're doing a pretty good job of, of this shit. This is crazy. Okay, let me see. Okay, to bar from defense present evidence and making arguments to the jury suggesting that they should be acquitted because the government engaged in misconduct in the course of its investigation. Okay, a whole bunch of case law there. All right, it says grant motion in limine to preclude evidence which is not relevant to defendant's guilt, but is designed only to persuade the jury that defendants should be acquitted because the government engaged in misconduct during its investigation. According to the government, moves to bar the defense from introducing evidence or argument of outrageous government conduct. C. Motion to preclude argument and evidence regarding the government's motion in investigating and prosecuting the case. The government moves to preclude evidence or argument by defense counsel regarding the government and the officers and agents' motivations for investigating or prosecuting this case. This includes, but is not limited to, arguments that the federal prosecution of defendants for child pornography offenses after Kelly's acquittal in Cook County Circuit Court is vindictive or otherwise improper. Evidence bearing on the government's decision to prosecute is extraneous and collateral and thus excluded from trial. Case law. The Seventh Circuit in 1979 affirmed the exclusion of evidence offered to show that the indictment was a political instrument. Case law. The Eighth Circuit in 2010 Selective prosecution of a criminal defendant is not an issue for the jury to decide. Further, the government moves to preclude the defense from arguing or eliciting evidence regarding the mental states, subjective intentions, or motivations of the investigating officers and agents. It is well settled law that inquiries regarding the subjective intentions or motivations of a government agent are irrelevant to determining the factual guilt or innocence of a defendant. God damn. Ooh. All right. Let me come around and check on y'all. See where we at. So y'all see what they're trying to do? Y'all figured it out? Okay, let's see. All right, so we got, let's see, more case law. It says Second Circuit, 1994, even in the context of an entrapment defense, it was proper for the trial court not to allow the defense to mount an inquiry into the mental states of the investigating officers since such evidence was irrelevant. According to the government, moves to preclude evidence or argument by the defense regarding the government and the officers and agents' motivations for investigating or prosecuting the case. It says motion to preclude argument and evidence of selective prosecution theory. Similarly, defendants should be precluded from introducing evidence or argument seeking to present a theory of selective prosecution before the jury. During the trial, the government intends to call witnesses who, for example, participated in the conspiracy to receive child pornography. Whoa. The government anticipates that defendant may argue that some of these witnesses may have been engaged in unlawful receipt of child pornography and have not been charged with any criminal offenses. Pursuant to federal rules of evidence 401 and 403, such information is irrelevant and unfairly prejudicial. Indeed, in United States versus Young, The Seventh Circuit, 1994, the court granted, on relevancy grounds, the government's motion to preclude the defendant from introducing evidence that another individual who had been arrested with him was not charged. In so ruling, the Young Court noted that the primary issue for the jury was whether the government met its burden of proof as to the defendant's knowledge and whether or not another individual was criminally charged, did not make the facts related to the defendant's knowledge and participation in the alleged crime more or less probable. Case law. The Sixth Circuit in 2006 observation that the defense of selective prosecution is a matter that is independent of a defendant's guilt or innocence, so it is not a matter for the jury. Wow. They are trying to box her in. In the same vein, defendants should be precluded from making legally irrelevant and prejudicial arguments regarding the parents of minors 1, 3, 4, 5, and 6. To prove the offenses alleged in the superseding indictment, the government expects to present evidence that some of the minor victims spent a substantial amount of time with defendants at the defendant's. Wait a minute. Okay. Some of the minor victims spent a substantial amount of time with defendants, and that defendants may try to deflect the blame. Oh, okay. I forgot it's more than one defendant. I'm sorry. May try to deflect the blame for their criminal conduct by offering evidence that the parents of the minor victims knew or should have known about their daughter's sexual relationship with Kelly. Defendants may further assert that to the extent the parents knew or should have known about the sexual relationship with Kelly, the parents thereby consented to such relationships. Such evidence has no legal bearing as to the offenses which the defendant are charged. Indeed, consent by either the parents or the minor victims is not a defense to such charges. Defendants may go so far as to argue that the parents of minor victims were responsible for or aided and abetted defendants' crimes. Such arguments are legally irrelevant and would only serve as a distraction to a jury. For all of these reasons, the government moves to preclude evidence or argument by the defense regarding any theory of selective prosecution. Wow. See, boy, they trying to block all her defenses. We're going to keep going, though. This is crazy. Number 10, motion to preclude discovery request or commentary regarding discovery in the presence of the jury. The government moves this court to preclude the parties from requesting discovery from witnesses or opposing counsel, moving the court for such discovery, or otherwise commenting on discovery matters in the presence of the jury. Such requests in front of the jury may distract the jury or create the impression that one side has suppressed information as a means of seeking an unfair advantage. Case law is Northern District in Indiana, March 26, 2010, granting government's motion to preclude the defense from requesting or commenting on discovery in presence of the jury. Case law. That's the Eastern District of, looks like Pennsylvania, September 17, 1996. Rather than focus on the issues in the case, the jury may instead be misled by the irrelevant side issues of the discovery process. Therefore, the court will not permit either party to refer to the discovery process in the presence of the jury at trial. As such, the government asks this court to prohibit either party from raising discovery issues in the presence of the jury. The appropriate time to raise such issues would be at a sidebar or while the jury is not in the courtroom. Number 11, motion to exclude evidence or arguments regarding the constitutionality of the statutes criminalizing the production and receipt of child pornography. Arguments pertaining to the constitutionality of the statutes criminalizing child pornography offenses are wholly irrelevant to the indictment in this case and do not affect the Supreme Court's and Seventh Circuit's unequivocal rulings that the First Amendment and the Commerce Clause does not protect child pornography. Case law. Let's see, rejecting a First Amendment challenge and upholding the constitutionality of laws prohibiting the possession and viewing of child pornography. Case law. The Second Circuit in 2000 rejecting a Commerce Clause challenging a conviction for possessing child pornography. For those reasons, the government moves to preclude defendants from introducing any evidence or arguments regarding the constitutionality of the statute criminalizing the production and receipt of child pornography. Number 12, motion to preclude argument and evidence of non-pertinent traits on defendants' characters. All right. The government moves this court to exclude all evidence offered by the defendant of their lawfulness and or non-corrupt conduct except reputation or opinion evidence offered by character witnesses strictly in accord with the limitations of Federal Rules of Evidence 405A, other than testimony from character witnesses fitting within the narrow confines of Rule 405A. No such evidence is admissible. Rule 404A1 precludes the admissibility of evidence of a person's character or character trait to prove that on a particular occasion the person acted in accordance with the character or trait. Federal Rule of Evidence 404A1, Rule 404A2 directs in relevant part that defendant may offer evidence of the defendant's pertinent trait. Federal Rules of Evidence 404A2A, pursuant to this rule, only pertinent character traits of defendant are admissible and all pertinent traits are inadmissible. All right. So you hear that. Let me reread it again. Pursuant to this rule, only pertinent character traits of defendant are admissible and all non-pertinent traits are inadmissible. For example, in an effort to distract the jury from the charges at issue, defendants may seek to call witnesses to testify that on particular prior occasions, defendant followed the law on otherwise behaved as lawful members of the community. Any evidence or argument of this sort is inadmissible, and the court should exclude it. The law is clear. Evidence that a defendant acted lawfully on other occasions is generally inadmissible to prove he acted lawfully on the occasion alleged in the indictment. Case law. The Seventh Circuit in 2012 stated that, the Seventh Circuit in 1990 stated that proof that a defendant acted lawfully on other occasions is not necessarily proof that he acted lawfully on occasions alleged in the indictment. To hold otherwise would be to eviscerate the carefully drafted limitations of Rule 405, which forbid proof of good character through evidence of specific acts where character is not an element of the charge or defense. Like Rule 403, Rule 405 is intended to prevent the series of wasteful mini trials, which would inevitably ensue if defendants were allowed to introduce irrelevant testimony of non pertinent traits of character. Accordingly, the government moves to bar defendants from presenting argument or introducing evidence of character traits of defendants that are non pertinent to refuting the elements of the offenses for which they are charged. Number 13, motion to preclude defenses of alibi or unavailability of mental defect. Oh, okay. Rules 12.1 and 12.2 of the Federal Rules of Criminal Procedures require that a defendant provide the government with notice of the following defenses. One, any alibi of similar defense that the defendant intends to raise, including any defense asserting that defendant's unavailability or on or near the dates named in the indictment. Rule 12.1 and 2, notice of any defense to be raised of a mental defect inconsistent with the state of mind required for the offense charged. Rule 12.2. On or about August 2nd, 2019, the government sent letters to defense counsel requesting notice pursuant to Rules 12.1, 12.2, and 12.3 of each of these defenses. The defendants have not notified the government of their intent to raise any such defenses. The government thus requests that the defendants be prohibited from introducing evidence argument relating to such defenses at trial. Boy, they trying to shut her the fuck down. Whew. 14. Motion to preclude defense counsel from defining the term reasonable doubt. God damn. Y'all, wait a minute. Wait a minute. Wait a minute. Wait a minute. Hold on for a minute, y'all. Hold on. I got to blow my damn nose. Hold on for a minute. Give me a minute. They trying to shut her the fuck down. They don't want her to do nothing. Hold on for a minute. Let me blow my nose, please. All right. Motion to number 14. Motions to preclude defense counsel from defining the term reasonable doubt. The government moves the court to order the defense not to attempt to define the term reasonable doubt during an opening statement or closing argument. The term reasonable doubt should not be defined by the trial court or counsel. Case law. The Seventh Circuit in 1995. Okay, that is because any attempt to define the term presents a risk without any real benefit. That is, any definition of the term often leans toward misleading refinements that weaken and make imprecise the existing phrase. Ugh, excuse me. Case law. That's a reference. Okay. Government argument was proper because it was invited by defense counsel's own improper attempt to define the reasonable doubt standard. The Seventh Circuit in 1993 stated, noting that definitions of reasonable doubt have a likelihood of confusing juries more than the simple words themselves. For these reasons, the Seventh Circuit has held that it is improper for attorneys to attempt to define the term reasonable doubt. Case law. It seems simple enough. We admonish counsel, do not define reasonable doubt to a jury. And it says committee comment to Seventh Circuit patterns criminal jury instruction. They really trying to shut her. They boxing her in. God damn. Number 15, motion to allow government to recall the case agent during its case in chief. Case in chief is simply the government's time to present the case, and the case in chief also is the defense time that when they present their case, not the cross-examining part of it, but their time to go. So that's their case in chief. All right. Says the government respectfully requests permission from the court to recall the case agent, a special agent from Homeland Security Investigations, during the course of trial so that testimony can be presented to the jury in an orderly and understandable manner and in a manner most effective for ascertaining the truth. This court has substantial discretion to determine the mode and order of interrogation. Case law. The Eighth Circuit in 1997 stated, upholding district court's decision to allow government to recall law enforcement witness so the evidence could be presented in chronological order. Federal Rule of Evidence 611A provides, in part, the court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to make those procedures effective for determining the truth and avoid wasting time. The Federal Rules of Evidence 611A, the procedure of permitting witnesses to testify in episodic or chronological order has been approved in complex conspiracy cases. A whole bunch of case law. Because the government intends to introduce, to the extent possible, evidence related to the conspiracy, which spans almost 20 years, and the substantive child exploitation charge chronologically, the government anticipates it will need to recall the case agent to testify about, among other things, voluminous bank and financial record of other business records from dozens of sources and multiple videos containing child pornography. While the government will attempt to limit the number of times it recalls the case agent as best it can, requiring her to testify only once would necessarily require the government to cover a broad number of topics out of chronological order in a fashion that would likely confuse the jury. Accordingly, the government respectfully requests that the court permit it to recall the case agent to testify to the relevant episodes of the government's investigation. The government further proposes that after each instance of direct examination, the defendants be permitted to cross examine the witness fully about any and all matters the witness testified about during the particular direct examination so as to ensure a full and fair cross examination. Number 16, motion to admit business records pursuant to federal rules of evidence 803A, 803.6 and 902.11. Under federal rules of evidence 902.11, certified copies of domestic businesses records are self-authenticating if the party offering the records provides the adverse party written notice and allows the adverse party to inspect the exhibit and certification, allowing the party to challenge the authenticity of the records. Under federal rules of evidence 803.6, the records are an exception of the hearsay rule if the following conditions exist. So remember, I was telling you about the shit have to be authenticated and validated, and the nature intent has to be there, right? This is, remember, I always tell y'all about when we were talking about the text messages and other things. This is exactly what it's saying about this particular evidence, I guess, regarding this domestic business records, right? And it says, let me back up some. It says, under the federal rules of evidence 803.6, the records are an exception to the hearsay rule if the following conditions exist. A, the records was made at or near the time by or from information transmitted by someone with knowledge. B, the record was kept in the course of a regularly conducted activity of business, organization, occupations, or calling, whether or not for profit. C, making the record was a regular practice of that activity. D, all of these conditions are shown by the testimony of the custodian or another qualified witness, or by certification that complies with Rule 902, 11, or 12, or with a statute permitting certification. And E, the opponent does not show that the source of the information nor the method or circumstances of preparation indicate a lack of trustworthiness. The Seventh Circuit has consistently upheld the admission of business records through business record certifications pursuant to Rules 803.6 and 902.11. The case law in Seventh Circuit in 2003, holding that admission of pre-certified business records under Rules 803.6 and 901.11 does not violate the Confrontation Clause because the records have sufficient guarantees of reliability. Now, remember, we was talking about the Confrontation Clause. I was talking about that. I told you that's going to be coming up anytime you're dealing with co-defendants and shit. Now, let's see what it talks about. Okay. Okay, so it does not violate the Confrontation Clause because the records have sufficient guarantees of reliability. There's a case law. The Seventh Circuit upheld the admissibility of records through the use of Rule 902.11 certification in light of Crawford. Remember, I brought up Crawford, right? I just brought up that earlier. I brought that up a couple of weeks ago, a few lives ago, about Crawford. Okay, Crawford has to do with the Confrontation Clause, right? The government moves the court to find, pursuant to Federal Rule of Evidence 104 that the records at issue are authentic business records within the meaning of Federal Rules of Evidence 8036. Rule 104 authorizes the court to determine in advance of trial preliminary questions concerning the qualifications of a person to be a witness, the existence of a privilege, or the admissibility of evidence. This rule applies to all preliminary determinations, including the questions of whether documents fall within the business records exceptions to the hearsay rule. Case law. Second Circuit in 1985 stated affirming trial court's preliminary determination pursuant to Rule 104 that business records were admissible pursuant to Rule 8036. The government intends to introduce a variety of business records through certifications, including the records of state agencies, financial institutions and companies, and hotel and other travel records. Government Exhibit 1 is a chart of business records for which the government intends to rely on business record certifications under Rules 8036 and 902.11. The business record certifications for records identified in the chart have been previously produced to defendant in discovery. Okay, that's business records. Okay. The government will send them to defense counsel again under separate cover. The chart in Government Exhibit 1 also identifies business records that are associated with each certification. The underlying business records have all previously been produced to defendants in discovery. The government intends to introduce selected portions of the business records identified in the chart at trial. Additionally, the government may supplement this notice as additional business record certifications and received from business custodians of record. Omissions of these documents through 902.11 certification will save the parties, the court, and the jury members significant time and resources, as the certifications will obviate the need for live witness testimony from several witnesses. Because the business records from the entities listed in Government Exhibit 1 and their accompanying certifications fall under Federal Rules of Evidence 902.11 and 8036, the government respectfully requests that this court find under Rule 104 that the identified business records fall within the business records exception to the hearsay rule. Conclusion. For these foregoing reasons, the United States respectfully requests that the court grants the government motions in limine. Okay, so we got some footnotes. Hold on, let me tackle those real quick. Because I did one of them. Okay, I did that one. Okay, 3. As noted in the government motion in limine, number 4 below is unknown at this time whether there would be sufficient room for spectators to be seated in the courtroom gallery for this trial. If there are spectators in the gallery, the government requests that the court admonish any courtroom sketch artist present that there shall be no sketches prepared of the victim witnesses' faces while they are testifying. It also may be appropriate to post notice of this order on the courtroom door. They're covering everything. Number 4, discovery related to the victim witnesses, including their full names and other identifying information, has been produced as sensitive material in this case. 5. Prior to trial, the government will submit the clip portions and any screenshots of the videos that it seeks to use for review by the court and defense counsel. Number 6. At this time, it is unknown whether there will be sufficient room for spectators to be seated in the courtroom gallery. If there are spectators in the gallery, the government requests that all monitors facing the gallery be turned around or otherwise turned off, that spectators cannot see the child pornography being displayed on the screens. In addition, if there is to be an overflow courtroom where spectators can view this trial, the government requests that the monitors in the overflow room be similarly turned around or turned off while child pornography videos and images are displayed during this trial. And also, notably absent from this motion in limine is the so-called 100 devices. We don't have any reference of them as of yet. I'm not saying that they're not there. I'm just saying it's not mentioned in this motion in limine, right? You can mention it here too, you know. Number 7. The government is also aware of an oral motion of the government being granted in the following case: United States versus Gabrielle 13, CR 718, Judge Tharp, United States. What is all that? Okay, all a bunch of case laws. I don't know why my nose keep getting clogged up, y'all. I have no idea. And it is so damn distracting. Number 8. Even evidence offered under Rule 405A cannot include specific instances of good conduct. It is limited to a description of the subject's reputation or to a brief statement of opinion without support from specific instances of conduct. See Advisory Committee Notes on Rule 405. The rule contemplates that testimony of specific instances is not generally permissible on direct examination of an ordinary opinion witness to character. Opinion testimony on direct in these situations ought in general to correspond to reputation testimony as now given, i.e., be confined to the nature and extent of observation and acquaintance upon which the opinion is based. Number 9, this motion constitutes written notice to defendants that the government intends to rely on business record certifications for the identified records. Number 10, the government will provide defendants with any additional certifications as they are received, and the Seventh Circuit has allowed notice to be provided only days before trial. The Seventh Circuit in 2003, the Seventh Circuit upheld the admission of business records pursuant to 902.11 certifications, even though the government gave defendant notice of its intent to use the certification only 4 days prior to trial. Number 11, the government may decide to call witnesses from one or more of the identified businesses if the witness has additional information beyond certification of the business records that would be helpful to the jury's understanding of the records. Now, it got an exhibit back here. So it says the business entity is American Express, and it's the financial records and account records for Daryl McDavid. You got Bank of America, and it's the financial statements and account records for minor one. Oh, you got Citibank financial statements and account records for Winkler and McDavid. You got the Department of Homeland Security, Customs and Border Protection. Travel records for minor one and her parents. Oh. You got Preferred travel records for Milton Brown. You got SunTrust Bank financial statements and account records for RSK Enterprises. And that's it. All right. So, did you see how they just mentioned him, Milton Brown, in that in the I'm on the screen, y'all. In the bank record shit. You see how they didn't, you see what I'm saying? You see, y'all caught what I'm saying? You see how they drug McDavid all through there, and we do know that there's a third co-defendant, Milton Brown. But see, the government took the time out in that one brief to let the judge see that this case should be, they should be joiners. They should be all co-defendants, and this case shouldn't be separate. So they drugged that man's name and attached him all with R. Kelly, all through the motherfucker. Yes, this is crazy. Oh my gosh. Then, okay, so now you getting to see what I was talking about at the start of this, right? You see how they're going, how the prosecutors are going by shutting down defenses. All right, they're trying to shut them down. Can't do this, can't do that, can't do this, can't do this, can't do this. All right. We don't have, we just still have the mentioning of the videos 1, 2, 3, and 4. We haven't seen anything about the 100 devices yet, the so-called 100 devices. Not saying that it's not there, not saying it won't show up. I'm just saying they could have mentioned it here. Yeah, right the hell. Did you see that? Did you catch it? So they're saying, baby, don't sever this motherfucker. They made sure. See, and these are just tricks, I'm sure everybody be like, oh, we'll repeat this. Like they discovered it. They came up with it. Oh, yeah. And yeah. Do your own work. We on our own. Do your own work. So let me see what y'all saying. So this is a lot, y'all. And listen, I'm just gonna be honest. This Chicago case is a motherfucker. No, baby. Lavelle, no, you can stop that because I know I put the mute on when I went to blow my damn nose. I know I did that. if I didn't, please tell me I did. And if I didn't, I'm sorry. I'm so sorry. Yes, so right, Karen, she is hardworking. She hardworking as hell. That's why she had to bring on somebody else from her law firm. This is too much. This is too much. This is too damn much. Child baby, I think Lynn was a great attorney too. Just keep messing with him and couldn't do his job. Right. This is absolutely nuts. They took that. Well, let's see. Let me go check and see if she put one in. Sky Lloyd, what's good with it?
Angie, bullshit ain't nothing but chewed up grass, baby. They can stop the motherfucking prize place.
What's up, girl? What's up? Girl, they got, let me tell you what they did. I'm gonna tell you. They saw how she get down, right?
Yeah.
And they said, okay, we got something for your little ass. We got something for your ass.
But guess what? if the people, this psychology 101, this emotional intelligence 101, and this is telling you that there's some bullshit on the scene and you better try and smell it. How you gonna tell me basically you gonna charge my client, but you want to scope my motherfucking defense? Okay?
Yeah.
You want to tell me what I can present for my client? I mean, like, come on. And you want to take, see, this is the thing. People have to understand. They presented all this stuff because they want you to look over here to the right. You see what I'm saying? And they want you to feel defeated. But really over here on the left, I think your shit ain't right. Why you got if your case so airtight, why you gotta direct my motherfucking defense? You see what I'm saying? If your shit is locked, cocked, and loaded, why you got to tell me how to present my defense?
Hey, Scott, baby, I'm not afraid your girl gonna be coming there with one vanilla envelope and shit.
I swear to God, look, I'm like, what is going on? What is going on?
Scott, she gonna have one vanilla envelope and she be like, bitch, where the paperwork? Where the case at?
I promise you. But wait, I need you to do me a favor. Now, and let me ask you this. Now, what the fuck is you and JoJo doing? Y'all gonna do a lab at the same time? So we can't be in two places. What is y'all doing?
Baby, he is doing him, and I'm doing. You ain't seen my live from this morning? Babe, see, listen, I don't have time to be being on relationships and stuff like that, honey. I don't have time.
Are you telling me y'all cut up? Oh my God.
I'm busy. Yeah, we're busy.
Oh my God. Okay, we'll have to talk about that later then. Okay.
Now you lie. I got my orange. I got my grape crush. Yes.
Let me say this. Do me a favor, please. Will you please read where the government, I was going to call them something else, where stated that they did not want the information regarding the parents' responsibility for their child. Can you please read that portion, please? And if Levi, if you out there, I need you to come up because we running it back.
Was that day?
Yes. They stated something they don't want the information about the parents responsible for their kids and the fact that they were knowingly willing participants and knew that their kids was having relationships with Kels. Yes, long story short.
It don't.
Yes, it did. Yes, it did.
Okay, here we go. Okay. And it's shit, because I done read all this shit here. I ain't said it stayed with me. Okay, in the same vein, defendants should be precluded from making legally irrelevant and prejudicial arguments regarding the parents of minors 1, 3, 4, and 5, and 6 to prove the offenses alleged in the superseding indictment. The government expects to present evidence that some of the minor victims spent a substantial amount of time with the defendant, and that the defendants may try to deflect the blame for their criminal conduct by offering evidence that the parents of the minor victims knew or should have known about their daughter's sexual relationship with Mr. Keller. Defendants may further assert, I remember reading this, defendants may further assert that to the extent the parents knew or should have known about the sexual relationship with Kelly, the parents thereby consented to such relationship. Such evidence has no legal bearing as to the offenses with which defendants are charged. Indeed, consent by either the parents or the minor victims is not a defense to such charges, right? Defendants may go so far as to argue that the parents of the minor victims were responsible for or aided and abetted defendants' crime. They probably listened to your ass and added this. Such arguments are legally irrelevant and would only serve as a distraction to the jury. Right? Okay, I remember that. Okay.
Yes. Bullshit.
They are cutting it, huh?
But look, I call bullshit because guess what, Angie? Remember what I told people when something happens, the question you ask is why. I'm asking you, why do you think they don't want that information to be put in the trial for the juries to hear.
But they just told you. One,
No,
it's
bullshit.
not relevant, and
It
two,
is, how's it not relevant?
confuse the jury.
Confuse the jury. So you're saying it's not relevant for you to let the jurors know how your minor child got into the arm's reach of this monster, Mr. Kelly? Are you telling me that's not relevant for us to know?
Yeah, we're going
how
through
that
this
happened.
again. Yeah, because it has nothing to do with the charges. Because you cannot, whether or not the parents knew or they didn't know, you cannot consent for your underage child to have sex with an adult.
We're not talking about consent. We're talking about a narrative explaining how your daughter got into the arm's reach of this monster R. Kelly. Why is that not relevant? This is a minor. You are responsible for your minor. This is what I'm trying to tell you, Angie.
Yeah.
If it wasn't a reason, they put that reason down, but the reason is this. Because they know once the jurors know that piece of that human factor,
yeah,
they know that it's over with. They trying to say it's going to confuse them. Oh, it's not going to confuse them. They know good and well that it is fucking aiding and abetting, that the goddamn parents aided and abetted, and it is selective prosecution. Everything they said it wasn't. That's exactly what it is.
And listen, and you know what? Legally, the prosecution can do that. It's aligned with the law. They gave the supporting law to support that. And you're absolutely right. But you can't do nothing about the legal factors in there. You can't do nothing about that. They got every right to cite that. One, it's not relevant. Two, it will confuse the jury.
You can cite that, but goddamn it, to me, that needs to be explained. How your minor baby daughter got into the grasp with this monster R. Kelly, and also they picked this up because guess what? The motherfucking text messages. Those goddamn text messages.
Let me tell you, LaBelle, I'm not saying either way. I just do the legal part. I don't know shit. I just do the legal part. I'm like Levi, I don't know nothing. I just do the legal. I'm just explaining to you how they get down. What you say now?
I'm saying, and the reason why they brought this up is because, and avoided it before, it's because of them goddamn text messages. Okay, them text messages are the same goddamn thing, because they didn't get in the last trial, and they damn sure don't want any type of information about the parents knowing what their child was doing, aiding and abetting in what their child was doing, and I want to see the.
You going out, Sky?
Okay, can you hear me?
I can hear you now. Yeah.
Yes, I want to see who cast these checks, baby. I want to see. See that this is the whole thing. The funny part is they should have left it alone, but you made sure you put it in there because you do not want the jury hearing that.
Yeah, like of course.
You are they don't want them to hear right. that. They don't want them to hear that.
You right. You absolutely right.
Yeah.
They don't want them to hear nothing about that bullshit. You right. But hey, that's just how it works.
But how was that? And I'm gonna have to think, because right now this is fresh off the rip. I'm gonna cover them 3 hours. Just give me a minute to, you know what I'm saying, marinate on this a couple days. I'm gonna come back with them 3 hours because I don't see how it's not relevant. What is it? Relevant, reliable, and what's that?
Reliable and relatable.
And relatable. Yep. Yeah. How's it not relatable to how that girl got there? I think the timeline is more crucial than anything else in this case.
If she tried to slip it in,
if they doing a timeline on how the fuck he abused these motherfuckers, why we can't do a timeline on how they got into his possession?
If she tried, if she just and they not gonna let her, but if she just saying that she wants the parents up there, maybe she could try this to speak to how the kids got to where they ended up. If you get to that part, But that's where the line of question is going to stop.
That's where it's gonna start, Angie. Because guess what? When they find out the parents cash them checks, that opens the goddamn door for the put their ass on the stand. You cast a check for your minor baby daughter to be in cahoots with the monster R. Kelly, who peed on minors, went to McDonald's and picked up minors.
They
Made the
shutting
girl eat
her ass
noodles.
down, baby. So now you get an example when I was telling you earlier about shutting down defenses. Now you saying they swinging and banging in Illinois like, bitch, no. She gonna come there with one piece of paper.
Let me say this. Let me say this.
Piece of paper, bitch, that's all
y'all,
I got.
But guess what, Angie? If they grant this shit, that lets you know right there. Because how you go? I mean, you are completely.
Y'all gonna turn it out?
Huh?
Y'all gonna turn it out? Y'all gonna turn Chicago?
No, we ain't gonna turn it out, but we gonna know what it is. You know what I'm saying? We gonna know what it is, because like you said, you boxing us in. You are creating his fucking defense.
Yeah.
You want to shape it, manipulate it. Why don't you just come on over here on our side and do it for him then? Okay. So we can make sure we say what the fuck you want us to say.
Exactly. What would you like for me to put on?
Right.
Now,
I'm sick of it.
Wonder, I think she probably gonna go off.
Oh yeah, I can't wait for this response. I cannot wait for this response. And I missed the beginning part. It's probably more I need to say, but that's what struck me. I said they glad them last text messages didn't get in about the parents aiding and abetting. That's the perfect A&A. And they damn sure don't want them to hear about it in this case. I tell you.
Yeah, they don't want none of that, honey.
I'm sick of
none of that.
Boy, I tell you, look, I was trying to sleep and I said, well, hold on, what's this? And I heard you, and I came in right at that part. I'm like, what? Oh, no. No, they ain't trying to do that. No, they not.
What kind of shit? Girl, now, they are trying all of it. They ain't giving a fuck.
They done got my attention. They got my attention on this one, Angie. The other one was bad at, but some bullshit. Now, you done got my attention on this. Cause
now you going in and know what you're looking for. Now you seeing they shutting down the fences. They doing this. They letting you know. Fuck you. That's what they letting you know. Fuck you. Well, fuck
what
you.
They call it? Design the course of the trial. I mean, really? And I'm telling you, that's how the parents gonna get in. If them parents signed a check, sent a letter, did any type of communication, it's opening the door. And we gonna walk in that motherfucker like, hi, let the games begin. Like say, shall we begin?
Yeah. That's crazy. That's crazy, honey. It is crazy.
But yeah, I just had to link that part. You know, somebody else might want to come up here, but I'll be in the chat listening. Look, and you know y'all throwing me in the cross now. Now I got to try and be on both channels. I'm sick of y'all. Letting you know.
Yeah, I don't have time for all this. I really don't. I'm too old for all this. I'm too old for all this, baby. I can't do all this, son. It's too much, baby. Sometimes it's too much shit for me. I ain't got time for this.
Yeah.
But
I'm in the chat. I'll come back if I hear something.
All right, later.
All right.
All right, Shay Dotton, D Boski, my Queen K, Queen everybody. I see you in that name, girl. I don't know about that one. La. Demisha Woods, Lil Mac Zoe, a very word. I got Lavelle. Let me see, Samantha Nicole. Samantha Michelle, that's it. That's all. Stilettos for me. The hell be swinging and banging and swinging. That's what she do. She give them the hell. Shaw baby. One. So Leslie Jennings, always, always. I said Karen J. Hey, hey, hey. Hey, Frank and Johnny Golden Oldies. Yeah, I think that's what that is. Mm-hmm. Mm-hmm. Progress to tie-ins. Who is that? Ms. What's something 1979, darling. I don't know about all that. Hush me. That's not. Who hushed you? I don't know what you're talking about, Miss something. Red Bunny. Red Bunny. Red Bunny. Red Bunny. In his finest. Listen. Miss me, Miss Mo. This crazy, y'all. This is crazy. Now, I don't know. I'm gonna be pissed off if I shut this down and then she come through and put her goddamn little motion and limit in. Oh, thank you, Shay. Yeah, get those likes up. All that goddamn reading. Look like I was gonna never stop. My nose keep getting stopped up. I'm not up. You can tell when I'm not under the cover. I get stopped up real quick. So this is what y'all face. So I shall, oh my gosh, shut this down. And we will wait, because I got time today. And see if she going to put hers in tonight. All right? Because you know she be behind and shit. But then she should be. Has anybody checked Twitter since she's back up? Did she say anything on Twitter? Let me see. Let me check. Let me check. Let me check. Nothing yet. What would she say? Let me give us a good song. Let me see. What should I play? I'm gonna play an old one, and ain't nobody gonna know this. Ain't nobody gonna know this one here. And if y'all do, I know y'all old as my ass. Hold on, let me see if I got it up. Hold on, let's go.
Rock on. Now my song and my posse along to the party container zone. From the heart is in effect, so I say body step. Think and learn, nigga move me made. Running those who just can't behave. It's a plan. There's a hand. It's from the big man too tough. All up in you with the family come from me, cause no one told ya. Of a level of serious saying, this ain't no joke, damn it, I ain't playing. I'm all for straight up raw. I'm the overlord, I dog clocking. But no, as if you didn't know, nothing on the scene when it's time to go. Ask for a number from any member of the tough crew band. Remember, walking on my tape over tip of my shoulder. That soldier, king roller, smashing doors, you stand in my path. Counting down like mad, landing, knocking, rapping them down. My brother town, girl. another verse of rap, another team of black star. Fill the vacuum, filling. So shot, start and rock to the point of no return, to the point of madness and burn. Started across seconds or new jack, because you never knew that to his back. Check out the scenery, yeah. You're not the future, your history. They try to compete and bust the good, but when they get a battle, where the fuck with you? Hardcore on wax and I'll sell it. That's how we roll, so that's how I tell it. Call it just, call it what you want, but the fact remains you're getting paid up for it. Tax free, money in my pocket, come from the ladies, cause I know they back superior. Hold the mic when needed. Surprise call, cycle completed. Fact I got my position is stronger. Remain a little just a little bit longer. As I found you down, the funky sounds of my part of town. Yeah. Spending dough, wasting time on a so-called rhyme, a so-called rapper with a so-called beat. All that shit is weak. And you tell me, man, I can't understand this too. And what we're coming to, what is wrong with you, what you trying to do? Yo, once again, the judge with the judge, the jury with fury to stop with the murder. Yes, of course, I rap cause you take no mistake, I cause you fake. BS walking, money is talking, I'll retaliate, but wait. For the beat, come back in, stop slacking off, cause I'm packing gems. Damn, name them all. You bring down the wall. Down with my boys, cause I gotta be down. From my part of town. Yeah. Yo, check this out. I want to say what's up to the danger zone posse from the north side, you know what I'm saying? You walking. Don't damn out. Turn around. Let's introduce the dope shouts out to all the fly skiers. How about you love for the knowledge? All I spot in action. A man that I'm leading at the top of the heat. To the Godfather bitch, got things all him up. Ain't checking the fact. What's so bad? T-Town, my part of town. Bust the fridge, you know what I mean? No one thing with my side to the danger zone posse. Special hard to my mom, 28th character, 24th Street, might see my brother trying. What's the dance? The dance at 80 for money, G, yeah, boy.
Yes, all right. I am going to get on up out of here. So what? Be good to yourself, be good to someone else. What is it? Be good to yourself, be good to someone else, and do something good for somebody else. Okay? Until the next live. Now she come back up and with her shit. Then just check for the notifications, honey. We'll be back. We're gonna read. J-Bull, what you gonna do? What you gonna do now? Where you gonna go now? The people don't box you in. The people gonna box you in. They say you can't do this, can't do that, can't say this, can't say that, can't present this, can't present that. I don't know what to tell you to do, J-Bo. Girl, you might as well just show up with a badge, bitch. I don't know what to tell you to do. Show up with a pencil and a pen and a highlighter. If I don't know what to tell you to do, I don't know what to tell you to do. This is fucked up. They done box you in. Twink, twink, twink. They done box you in. Baby, they said can't do this, can't do that. Can't walk here, can't walk there. Can't look at this, can't look at that. I don't know what to tell you. Can't read this, can't read that. Can't bring this here, can't bring that there. Can't have that evidence, can't do that. I don't know what to tell you. Girl, I don't know what to tell you. Baby. I don't know what to tell you. Honey, but good luck. I don't know what to tell you. Come up with something real good, baby. Because I want to read what you got to say. Because we nosy as fuck. over here. All right, y'all. To the next slide, to the next one.